This is A.thim reading Chapter 1, The Nature, Purpose, and Function of Criminal Law. May the police officers be subjected to prosecution in both state and federal court. As the videotape begins, it shows that King rose from the ground and charged towards Officer Powell. Powell took a step and used his baton to strike King on the side of his head. King fell to the ground from the 18th to the 30th second on the videotape. King attempted to rise, but Powell and Wynn each struck him with their batons to prevent him, and Wynn each struck with him with their batons to prevent him from doing so. From the 35th to the 51st second, Powell administered repeated blows to King's lower extremities. One of the blows fractured King's legs. At the 55th second, Powell struck King on the chest, and King rolled over and lay prone at that point. The officer stepped back and observed King for about 10 seconds. At 1 minute and 5 seconds on the videotape, Briseno in the district court's words stomped on King's upper back or neck. King's body writhed in response. At 1:07, Powell and Wynn began again to strike King with a series of baton blows, and Wynn kicked him in the upper thoracic or cervical area 6 times until 1:26. At about 1:29, King put his hands behind his back and was handcuffed. Introduction. Criminal law is the foundation of the criminal justice system. The law defines the conduct that may lead to an arrest by the police, trial before the courts, incarceration in prison. When we think about criminal law, we typically focus on offenses such as rape, robbery, murder. States, however, condemn a range of acts in the criminal codes, some of which may surprise you. In Alabama, it is a criminal offense to promote and engage in a wrestling match with a bear, or to train a bear to fight in such match. A Florida law states that it is unlawful to possess any ignited tobacco product in an elevator. Rhode Island declares that an individual shall be imprisoned for 7 years who voluntarily engages in a duel with dangerous weapon or challenges an individual to a duel. In Wyoming, you can be arrested for skiing while being impaired by alcohol, or opening and falling too close a gate fence that crosses a private road or river. You can find criminal laws on the books in various states punishing activities such as playing dominoes on Sunday, feeding an alcoholic beverage to a moose, cursing on a miniature golf course, making love in a car, or performing a wedding ceremony when either the bride or groom is drunk. In Louisiana, you risk being sentenced 10 years in prison for stealing an alligator, whether dead or alive, valued at $1,000. The nature of criminal law is there is common characteristics of acts that are labeled as crimes. How do we define a crime? The easy answer that is a crime is whatever the law declares to be criminal offense and punishes with a penalty. The difficulty with this approach is that not all criminal convictions result in a fine or imprisonment. Rather than punishing a defendant, the judge may merely warn him to her or her to not to repeat the criminal act. Most commenters stress that the important feature of a crime is that it is an act that is officially condemned by a community and carries a sense of shame and humiliation. Professor Henry M. Hart, Jr. defines a crime as conduct which, if shown had to be taken place, will result in the formal and solemn pronouncement of a moral condemnation of the community. The central of Professor Hart's definition is the crime is subject to a formal condemnation by the judge and jury representing the people in a court of law. This distinguishes a crime from acts most people would find objectionable that is typically or not subject to state prosecution and official punishment. We might, for instance, criticize someone who cheats on his or her spouse, but we generally leave the solution to individuals involved. Other matters are left to institutions to settle. Schools generally discipline students who cheat or disrupt classes, but this really results in criminal charge. Professional baseball, basketball, and football leagues have their own private procedures for disciplining players. Most states leave the decision whether to recycle trash to the individual and look to the peer pressure to enforce this obligation. Criminal and civil law. How does a criminal law differ from civil law? Civil law is the branch of the law that protects the individual rather than the public interest. A legal action for a civil wrong is brought by an individual rather than by a state prosecutor. You may sue a mechanic who breaches a contract to repair your car, or bring an action against a landlord who fails to adequately heat your apartment. The injury is primarily to you as an individual, and there is relatively little harm to society. A mechanic who intentionally misleads and harms a number of innocent consumers, however, may find himself or herself charged with criminal fraud. Civil and criminal actions are characterized by different legal procedures. For instance, conviction of crime requires the high standard of proof beyond a reasonable doubt, although responsibility for a civil wrong is established by the much lower standard of proof by preponderance of the evidence is roughly 51% certainty. The high standard of proof in criminal cases reflects the fact that a criminal conviction may result in loss of liberty, significant damage to an individual's reputation and standing in the community. The famous 18th century English jurist William Blackstone summarizes the distinction between civil and criminal law by observing the civil injuries and infringement of the civil rights which belong to individuals. Public wrongs or crimes are a breach and violation of the public rights and duties due to the whole community in its social aggregate capacity. Blackstone illustrates this difference by pointing out that society has little interest in whether someone sues a neighbor or emerges victorious in land dispute. On the other hand, society has a substantial investment in the arrest, prosecution, conviction of individuals responsible for espionage, murder, and robbery. The difference between a civil and criminal action is not always clear, particularly with regard to an action for a tort, which is an injury to a person or to his or her property. Considered drunk driver who runs a red light and hits your car. The driver may be sued in tort, negligently damaging you and property, as well as criminally prosecuted for reckless driving. The purpose of the civil action is to compensate you with money to damage to your car and the physical and emotional injuries you have suffered. In contrast, the criminal action punishes the driver for endangering society. Civil liability is based on preponderance of the evidence standard, while criminal conviction carries a possible loss of liberty and is based on the higher standard of guilt beyond a reasonable doubt. You may recall the former football star O.J. Simpson was acquitted of murdering Nicole Brown Simpson and Ron Goldman, but was later found guilty of wrongful death in a civil court and ordered to compensate the victims' families amount of $33.5 million. The distinction between criminal and civil law proved immensely significant for Kansas inmate Leroy Hendricks. Hendricks was about to be released after serving 10 years in prison for molesting two 13-year-old boys. This was only the latest episode in Hendricks' almost 30-year history of incident exposure and molestation of young children. Hendricks freely conceded that when not confined, the only way to control his sexual urge was to die. Upon learning that Hendricks was about to be released, Kansas authorities invoked the Sexually Violent Predator Act of 1994, which authorized the institutional confinement individuals due to mental abnormality or personality disorder are likely to engage in predatory acts of sexual violence. Following a hearing, a jury found Hendricks to be a sexual predator. The U.S. Supreme Court ruled that Hendricks' continued commitment was civil rather than criminal penalty, and that Hendricks was not being unconstitutionally punished twice for the same criminal act of molestation. The court explained that the purpose of the commitment procedure was to detain and treat Hendricks in order to prevent him from harming others in the future rather than punish him. Do you think the decision of the U.S. Supreme Court makes sense? The purpose of criminal law. We have seen that criminal law primarily protects the interests of society, and civil law protects the interests of individual. The primary purpose of a functioning criminal law is to help maintain social order and stability. The Texas Criminal Code proclaims that the purpose of the criminal law is to establish system prohibitions, penalties, correctional measures to deal with conduct that unjustifiably and inexcusably causes, threatens harm to those individual and public interests for which state protection is appropriate. The New York Criminal Code sets out the purpose of the criminal law follows: harm to prohibit conduct that unjustifiably, unexcusably causes, warning to warn people, definition to define an act and intent ascribed to the offense, seriousness to distinguish between serious and minor offenses, punishment to impose punishment to satisfy demands of revenge, rehabilitation, victims to ensure the victim's family and the community interests represented at the trial is imposing punishments. The next step is to understand the characteristics of criminal act, the principles of criminal law. The study of substantive criminal law involves an analysis, determination of specific crimes, specific part of the general principles that apply to all crimes, general parts such as the defense of insanity. In our studies, we will first review the general part of criminal law and then look at specific offenses. Substantive criminal law, it is distinguished from criminal procedure. Criminal procedure involves a study of legal standards governing detection, investigation, and the prosecution of crime. Includes areas such as interrogations, search, seizure, wiretapping, and the trial process. Criminal procedure is concerned with how the law is enforced. Criminal law involves the law. What is law enforced? Professors Jerome Hall and Wayne R. Lefebvre identify the basic principles that is Identify the basic principles that compose the general part of criminal law. Think of the general part of the criminal law as building blocks that are used to construct specific offenses such as rape, murder, and robbery. Criminal act: A crime involves act of failure act. You cannot be punished for bad thoughts. A criminal act is called actus reus. Criminal intent: a crime requires criminal intent or mens rea. Criminal punishment is ordinarily directed at individuals who intentionally, knowingly, recklessly, and negligently harm others, individuals, or property. We now turn to a specific part of the criminal law to understand the various types of that act are punished as crimes. Categories of crime: felonies and misdemeanors. There are a number of approaches to categorizing crimes. The most significant distinction is between a felony and a misdemeanor. A crime punishable by death or by imprisonment for more than 1 year is a felony. Misdemeanor are crimes punishable less than a year in prison. Note that whether conviction is for a felony or a misdemeanor, it is determined by punishment provided by the statute under which an individual is convicted, or rather than by the actual punishment imposed. Many states subdivide felonies and misdemeanors into several classes or degrees to distinguish between the seriousness of criminal acts. Capital felonies are crimes subject either to death penalty or to life in prison. In states that do not have the death penalty, the term gross misdemeanor is used in some states to refer to crimes subject between 6 and 12. Gross misdemeanor is used in some states to refer to crimes subject between 6 and 12 months in prison, whereas other misdemeanors are termed petty misdemeanors. Several states designate a third category of crimes that are termed violations and infractions. These tend to be acts that cause only modest social harm, carry fines. These offenses are considered so minor that imprisonment is prohibited. These include violation of traffic regulations. Florida classifies offenses as felonies, misdemeanors as non-criminal violations. Non-criminal violations are primarily punishable by fine, forfeiture of property. The following list shows the categories of felonies and misdemeanors, maximum punishment generally allowable under federal law. The severity of a punishment imposed based on seriousness of the particular offense. Florida, for example, punishes a second-degree felony the recruitment of an individual, prostitution, knowing that force, fraud, or coercion will be used to cause the person to engage in prostitution. This same act punished as a first-degree felony in the event that the person recruited is under 14 years old or if death results. Mala in se and mala in prohibita. Another approach is to classify the crime by moral turpitude. Mala in se crimes are considered inherently evil and will be evil even if not prohibited by law. This includes murder, rape, robbery, burglary, larceny, and arson. Mala prohibita offenses are not inherently evil and are considered only wrong because they are prohibited by a statute. This includes offenses ranging from tax evasion to carrying concealed weapon, leaving the scene of an accident, and being drunk in disorderly public. Why should we be concerned with classification schemes? A felony conviction can prevent you from being licensed to practice various professions, bar you from being admitted to armed forces or joining the police, and prevent you from adopting a child or receiving various forms of federal assistance. In some states, a convicted felon is still prohibited from voting, even following release. The distinction between mala in se and mala in prohibita is always also important. For instance, the law provides the individuals convicted of a crime of moral turpitude may be deported from the United States. There are a number of classification schemes. The law originally categorized as infamous those crimes were considered to be deserving of shame, disgrace. Individuals convicted of infamous offenses such as treason, betrayal of the nation, or offenses involving dishonesty were historically prohibited from appearing as a witness at a trial. Subject matter. This textbook is organized in accordance with the subject matter of crimes. The scheme that is followed is in most state criminal codes. This disagreement, however, concerning the classification of some crimes, robbery, for instance, involves the theft of property as well as the threat of infliction to harm to the victim, and there is a debate about whether it should be considered a crime against property or against a person. Similar issues arise in regard to burglary. Subject matter offenses in the descending order of seriousness are as follows. The book also covers the general part of criminal law, including the constitutional limits on the law, Chapter 2, Sentencing, Chapter 3, Criminal Acts, Chapter 4, Criminal Intent, Chapter 5, the scope of criminal liability, Chapter 6 and 7, and the defenses of the criminal liability, Chapter 8 and 9. Sources of criminal law. We now have covered the various categories of criminal law. The next questions to consider are these. What are the sources of criminal law? How do we find requirements of law? There are a number of sources criminal law in the United States. At this point, we turn our attention to the common law origins of American law and state criminal codes. The common law, the English common law, is the foundation of American law. The origins of common law can be traced to Norman conquest of England 1066. The Norman King William the Conqueror was determined to provide a uniform law for England and sent royal judges throughout the country to settle disputes in accordance with the common customs and practices of the country. The principles of composed this common law began to be written down in 1300 in an effort to record the judge-made rules that should be used to decide future cases. By 1600, a number of common law crimes had been developed, including arson, burglary, larceny, manslaughter, mayhem, rape, robbery, sodomy, and suicide. These were followed by criminal attempt, conspiracy, blasphemy, forgery, sedition, solicitation. On occasion, the king and the parliament issued decrees that filled the gaps in the common law, resulting in the development of the crimes of false pretenses and embezzlement. The distinctive characteristics of a common law is that it is for the most part the product of the decisions of judges in actual cases. The English civil and criminal common law was transported to the new American colonies and formed the foundation of the colonial legal system that is in turn was adopted by the 13 original states following the American Revolution. The English common law was also recognized by each state subsequently admitted to the Union. The only exception was Louisiana, which followed the French Napoleonic Code until 1805, when it was embraced the common law. State criminal codes. States in the 19th century began to adopt comprehensive written criminal codes. This movement was based on the belief that in a democracy, the people should have the opportunity to know the law. Judges in the common law occasionally punished an individual for an act that had never been subjected to prosecution. A defendant in Pennsylvania case was convicted of making obscene phone calls despite of the absence in previous prosecution for this offense. The court explained that the common law is sufficiently broad to punish, although there may be no exact precedent. Any act which directly injures or tends to injure the public. There was additional argument that the power to make laws should reside in elected legislative representatives of the people rather than in unelected judges. As Americans began to express a sense of independence, there was also a strong reaction against being so clearly connected to the English common law tradition, which was thought to have limited relevance to challenges facing America as early as 1812. The U.S. Supreme Court proclaimed that the federal courts were required to follow the law established by Congress and were not authorized to apply the common law. States were somewhat slower than the federal government and abandoned the common law in a main case. In 1821, the accused was found guilty of dropping the dead body of a child into a river. The defendant was convicted even though there was no statute of making this crime. The court explained that the good morals and decency all forbid this act. State legislatures reacted against these types of decisions and began abandoning the common law. In mid-19th century, the Indiana Revised Statutes 1852, for example, proclaimed that crimes and misdemeanors shall be defined and punished to fixed by statutes of the state and not otherwise. Some states remain common law states, meaning that the common law may be applied where the state legislature has not adopted a law in a particular area. The Florida Criminal Code states that the common law of England in relation to the crimes, except so far as the same relates to the mode and degrees of punishment, shall be full force in the state where there is no existing provision by statute on the subject. Florida law further provides that there is no statute and offense shall be punished by fine and imprisonment, but that the fine shall not exceed $500, nor the term imprisonment 12 months. Missouri and Arizona are examples of common law states. These states' criminal codes, like that of Florida, contain reception statute that provides that the states receive the common law as unwritten part of their criminal law. California, on the other hand, is an example of code jurisdiction. The California Code provides that no act or omission is criminal or punishable except as prescribed or authorized by this code. Ohio and Utah are always code jurisdiction states. The Utah criminal codes that common law crimes are abolished and no conduct is a crime unless made so by this code or ordinance. Professor Lave observes that courts in the common law states have recognized a number of crimes that are not part criminal codes, including conspiracy, attempt, solicitation, uttering gross obscenities in public, keeping a house of prostitution, cruelly killing a horse, public inebriation, or false imprisonment. You also should keep in mind that the common law continues to play a role in the law code jurisdiction states. Most state statutes are based on common law, and courts frequently consult the common law to determine the meaning of terms and statutes. In the well-known California case, Keeler versus Superior Court. The California Supreme Court looked to the common law and determined that an 1850 state law prohibiting the killing of a human being did not cover the murder of a fetus. The California state legislature then amended the murder statute to punish the unlawful killing of a human being or fetus. Most important, our entire approach to criminal trials reflects the common law's commitment in protecting the rights of the individual in the criminal justice process. State police power or their limit on states' authority to pass criminal laws. Could a state declare that it is a crime to possess fireworks on July 4th? State government possess the broad power to promote the public health, safety, and welfare of the resident state. The wide-ranging police power includes the duty to protect the well-being, tranquility of community, and to prohibit acts or things reasonably thought to bring evil or harm to people. An example of far-reaching nature of state police power is the U.S. Supreme Court's holding of the right of a village to prohibit more than two unrelated people from occupying a single home. The Supreme Court proclaimed that the police officer includes the right to lay out zones where family values, youth values, the blessings of quiet seclusion and clean air make the area a sanctuary for people. State legislatures, in formulating the content of criminal codes, have been profoundly influenced by the Model Penal Code. The Model Penal Code. People from other countries often ask how students can study criminal law of the United States, a country of 50 states and federal government. The fact that there is a significant degree of agreement in the definition of crimes in state codes is due to a large extent of Model Penal Code. In 1962, the American Law Institute, private group, lawyers, judges, and scholars concluded after several years of study that despite our common law heritage, state criminal statutes radically varied in their definition of crimes, were difficult to understand and poorly organized. The ALI argued that the quality of justice should not depend on the state, which is an individual was facing trial, issued to a multi-volume set of model criminal laws to propose official draft of Model Penal Code. The Model Penal Code is purely advisory and is intended to encourage all 50 states to adopt single uniform approach to criminal law. The statutes are accompanied by a commentary that explains how the Model Penal Code differs from existing state statutes. Roughly 37 states have adopted some provisions of the Model Penal Code, although no state has adopted every single model law. The state that most closely follow the code are New Jersey, New York, Pennsylvania, and Oregon. As you read this book, you may find it interesting to compare the Model Penal Code to the common law and the state statutes. This book primarily discusses state law, criminal law. It is important to remember that we also have a federal system of criminal law in the United States. Federal statutes in the United States has a federal system of government that states granted various powers to the federal government that are set forth in the U.S. Constitution. This includes the power to regulate, investigate commerce, to declare war, to provide the national defense, coin money, to collect taxes, to operate the post office, and to regulate immigration. The Congress is entitled to make all laws which shall be necessary and proper for fulfilling these responsibilities. The states retain powers that specifically granted to the federal government. The 10th Amendment to the Constitution states the power is not delegated to the United States by the Constitution nor prohibited by its states are reserved to the states respectively or to the people. The Constitution specifically authorizes Congress to punish the counterfeiting of the U.S. currency, piracy, and felonies committed on the high seas and crimes against the law of nations, as well as making rules concerning the conduct of warfare. These criminal provisions are to be enforced by single Supreme Court by additional courts established by Congress. The Federal Criminal Court complies the criminal laws adopted by the U.S. Congress. This includes the law punishing acts such as tax evasion, mail immigration fraud, bribery, and obtaining a government contract, and knowing the manufacture of defective military equipment. The Supremacy Clause of the U.S. Constitution provides the federal law and the superior the state law within the areas of that are preserved of the national government. This is termed preemption doctrine. In 2012, the Supreme Court held a federal immigration law preempted several sections of and an Arizona statute directed and undocumented individuals. Several recent court decisions have held the federal criminal laws have unconstitutionally encroached on areas served for the state governments. This reflects a trend toward limiting the Commerce Clause, has interpreted its power to regulate interstate commerce as providing the authority to criminally punish harmful acts to involve the movement of goods or individuals across the state lines. An obvious example is the interstate transportation of stolen automobiles. In the past few years, the U.S. Supreme Court has ruled that several federal laws unconstitutional based on the fact that the activities did not clearly affect interstate commerce or involve the use of interstate commerce. In 1995, the Supreme Court ruled in United States versus Lopez that Congress violated the Constitution by adopting the Gun-Free School Zones Act of 1990, which made it a crime to have a gun in a local school zone. The fact that the gun may have been transported across state lines, which was too indirect a connection with interstate commerce on which the base federal jurisdiction. In 2000, the Supreme Court also ruled unconstitutional the U.S. government prosecution of an individual in Indiana who was alleged to have set fire to a private residence. The federal made it a crime to maliciously damage and destroy by means of fire or an explosive any building used to interstate or foreign commerce or any activity affecting interstate or foreign commerce. The Supreme Court ruled that there must be direct connection between building and interstate commerce, rejected government's contention that it is sufficient that a building is constructed of supplies or serviced by electricity that moved across the state lines, or that the owner's insurance payments are mailed to a company located in another state. Justice Ruth Bader Ginsburg explained that this would mean that every building in the land would fall within the reach of federal laws on arson, trespass, and burglary. In 2006, Oregon versus Gonzalez, the Supreme Court held that U.S. Attorney General John Ashcroft lacked the authority to prevent Oregon physicians acting under the state deaths of dignity law from prescribing lethal drugs to terminally ill patients who are within 6 months of dying. The sharing of a power between the federal and state governments is termed dual sovereignty. An interesting aspect of dual sovereignty that is constitutionally permissible to prosecute the defendant for the same act at both state federal levels so long as the criminal charges slightly differ. The double prosecution does not constitute double jeopardy. You might recall in 1991 that Rodney King, an African American stopped by Los Angeles police. King resisted and eventually subdued, wrestled to the ground, beaten, handcuffed by 4 officers. The officers were acquitted by an all-Caucasian jury in the state court in Simi Valley, California, leading to the widespread protests and disorder in Los Angeles. The federal government responded by bringing the 4 officers to trial for violating King's civil right to be arrested in a reasonable fashion. 2 officers were convicted and sentenced to 30 months in federal prison, and 2 were acquitted. Later in this chapter, you will be asked to decide whether this double prosecution is fair. We have seen the federal government possess the power to enact criminal laws. The federal law is restricted by the provisions of the U.S. Constitution to define their limits on governmental power. Constitutional limitations. The U.S. Constitution and individual state constitutions limits the standards for criminal law. The U.S. Constitution, as we shall see in Chapter 2, requires the following. A state or local law may not regulate an area that is reserved. The ability of legislators to enact criminal laws is also limited by public opinion. The American Constitution system is a democracy. Politicians are fully aware that they must face elections and they may be removed from office in the event that they support unpopular law, as we learned during the unsuccessful effort to ban the sale alcohol during the Prohibition era in the early 20th century. The government will experience difficulties in imposing unpopular law to the public. Crime in the news. In 1996, California became one of the 23 states to authorize the use of marijuana for medical purposes. The other states are Alaska, Arizona, Colorado, Connecticut, Delaware, Hawaii, Illinois, Maine, Maryland, Massachusetts, Michigan, Minnesota, Montana, Nevada, New Hampshire, New Jersey, New Mexico, New York, Oregon, Rhode Island, Vermont, Washington. And the same applies in the District of Columbia. Maryland exempts medical marijuana uses from jail sentences. California voters passed Proposition 215, the Compassionate Use of the Act of 1996, which is intended to ensure the seriously ill residents of California are able to obtain marijuana. The act provides an exemption from a criminal prosecution for doctors who, in turn, may authorize and primary caregivers to possess or cultivate marijuana for medical purpose. Says the California legislation is directly at odds with the Federal Controlled Substances Act, which declares it's a crime to manufacture, distribute, or possess marijuana. There are more than 100,000 medical marijuana users in California, and roughly 1/10 of the 1% of the population uses medical marijuana. In the states that collect information on the medical marijuana users, Angel Rach and Diane Monson are two California residents who suffer from severe medical disabilities. Their doctors have found that marijuana is the only drug that is able to alleviate their pain and suffering. Rach's doctor goes so far as to claim that Angel's pain is so intense that she might die if deprived of marijuana. Monson cultivates her own marijuana, and Rachel relies on two caregivers to provide her with California-grown marijuana at no cost. On August 15, 2000, agents from the Federal Drug Enforcement Administration raided Monson's home and destroyed all 6 of her marijuana plants. The DEA agents disregarded objections from the Butte County Sheriff's Department and local California District Attorney's Office. The Monson's possession of marijuana was perfectly legal. Monson and Rach, along with several doctors and patients, refused to accept the destruction of the marijuana plants and asked the U.S. Supreme Court to rule on the constitutionality of the federal government's refusal to exempt medical marijuana users from criminal prosecution and punishment. The case was supported by the California Medical Association and the Leukemia and Lymphoma Society. Rach suffers from severe chronic pain stemming from fibromyalgia, endometriosis, scoliosis, uterine fiber tumors, rotator cuff syndrome, inoperable brain tumor, seizures, life-threatening wasting syndrome, and constant nausea. She also experiences extreme chemical sensitivities that result in violent allergic reactions to virtually every pharmaceutical drug. Rach was confined to a wheelchair before reluctantly deciding to smoke marijuana, a decision that led her to enjoying fairly normal life. A doctor recommended that Monson use marijuana to treat severe chronic back pain and spasms. She alleges that marijuana alleviates the pain that she describes as comparable to an uncontrollable cramp. Monson claims that other drugs have proven ineffective, resulted in nausea, and created the risk of severe injuries to her kidneys and liver. The marijuana reportedly reduces the frequency of Monson's spasms and enables her to continue to work. The U.S. Supreme Court in Gonzalez v. Raich in 2005 held a federal prohibition on the possession of marijuana would be undermined by exempting marijuana possession in California and other states from federal criminal enforcement. The Supreme Court explained that the cultivation of marijuana under California's medical marijuana law, although clearly locally activity, frustrated federal government's effort to control the shipment of marijuana across state lines because medical marijuana inevitably would find a way into interstate commerce, increase the nationwide supply, and drive down the price of the legal drug. There was also a risk that the completely healthy individuals in California would manage to fraudulently certify by a doctor to be in need of medical marijuana. 3 of the 9 Supreme Court judges dissented from the majority opinion. Justice Sandra O'Connor observed that the majority judgment stifles an express choice by some states concerned for the lives and liberties of their people to regulate medical marijuana differently. Following the decision, Angel Raich urged the federal government to have some compassion and have some heart and not to use taxpayer dollars to come in and lock us up. We're using this medicine because it is saving our lives. She asked why federal government was trying to kill her opponents of the medical marijuana defend the Supreme Court's decisions, and explained that individuals should look to traditional medical treatment rather than being misled into thinking that marijuana is an effective therapy. They also argue that marijuana is a highly addictive drug that could lead to individuals to experiment with even more harmful narcotics. Obama administration initially did not enforce federal marijuana law against individual medical marijuana states. In 2011, the Department of Justice announced that although individuals could grow and use small amounts of medical marijuana, that DOJ would originally prosecute growers for more than 100 plants and individuals involved in the commercial marketing and sale of marijuana. In 2013, the Obama administration reversed the course and announced that it would not prosecute individual medical marijuana states unless the individuals threaten certain federal law enforcement interests. This includes the distribution of marijuana to minors, providing revenue to criminal enterprises, diversion of marijuana to states where marijuana remains illegal, and the possession of marijuana is federally property. In 2014, Congress adopted a law prohibiting the Justice Department from using resources to prevent states from implementing their own state laws authorized to use distribution, possession, and cultivation of medical marijuana. Where do you stand on the medical marijuana controversy? Of course, the democratic will of the majority is subject to constitutional limitations. A classic example of Supreme Court's ruling that popular federal states prohibiting and punishing flag burning, discretion, compose unconstitutional violation, freedom of speech. Consider the following factual scenario that is taken to the U.S. Supreme Court's description of the events surrounding the beating of Rodney King. You decide 1.1. On the evening of March 2nd, 1991, Rodney King and 2 of his friends sat and King's wife in a car in Altadena, California, in the city of Los Angeles County, and drank malt liquor for a number of hours. Then, with King driving, they left Altadena via major freeway. King was intoxicated. California Highway Patrol officers observed King's car traveling at a speed they estimated to be in excess of 100 miles per hour. The officers followed King with red lights and sirens activated and ordered him by a loudspeaker to pull over, but he continued to drive. The Highway Patrol officers called on the radio for help. Units of the Los Angeles Police Department joined the pursuit, one of them manned by Petitioner Lawrence Powell and his trainee Timothy Wynn. The officers are all Caucasian. King was an African American. King later explained that he fled because he feared that he would be returned to prison after being released 4 months earlier following the year spent behind bars for robbery. King left the freeway and after chased about 8 miles, stopped at an entrance or recreation area. The officers ordered King and his 2 passengers to exit the car and to assume the felony-prone position, that is, to lie on their stomachs, legs spread, arms behind their backs. King's 2 friends compelled King to got out the car but did not lie down. Petitioner Stacy Kuhn arrived at once, followed by Ted Persono and Roland Solano. All were officers of the Los Angeles Police Department, and as Sergeant Kuhn took charge, the officers again ordered King to assume the felony-prone position. King got on his hands and his knees and did not lie down. Officers Powell, Wynn, Persono, and Solano tried to force King down, but King resisted and became combative. So the officers retreated. Kuhn then fired tasers, darts designed to stun a combative suspect, into King. The events that occurred next were captured on videotape by bystanders. As the videotape begins, it shows that King rose from the ground and charged toward Officer Powell. Powell took a step and used his baton to strike King on the side of his head. King fell into the ground. From the 18th to the 30th second on the video tape, King attempted to rise, but Powell, Wynn each struck him with their batons to prevent him from doing so. From the 35th to the 51st second, Powell administered repeated blows to the King's extremities. One of the blows fractured King's leg. At the 55th second, Powell struck King on the chest, and King rolled over and lay prone. At that point, the officer stepped back and observed King for about 10 seconds. Powell began to reach for his handcuffs. At the sentencing phase, district found that Powell no longer perceived King to be a threat at this point. At 1 minute 5 seconds on the video tape, Persano in the district court's words stomped on King's upper back or neck. King's body writhed in response. At 1:07, Powell and Wynn again began to strike King with a series of baton blows, and Wynn kicked him in the upper thoracic cervical area 6 times until 1:26. About 1:29, King put his hands behind his back and was handcuffed. Powell radioed for an ambulance. He sent 2 messages over the communication network to the officers that said, "Oops, and I haven't beaten anyone this bad in a long time." Kuhn sent a message to the police station said, "Unit has had a big time use of force. Tase beat suspect of CHP pursuit. Big time." King was taken to the hospital where he was treated for a fractured leg, multiple facial fractures, a number of numerous bruises, contusions. Learning that King worked at Dodger Stadium, Powell said that King, "We played a little ball tonight, didn't we, Rodney? You know, we played a little ball. We played a little hardball tonight. We hit quite a few home runs. Yes, we played a little ball and you lost and we won." Kuhn, Powell, Briseno, and Wynn were tried in California State on charges of assault with a deadly weapon and excessive use of force by police officers. The officers were acquitted of all charges, with the exception of one assault charge against Powell that resulted in a hung jury. The jury, composed of 10 Caucasians, 1 Hispanic, 1 Asian American. The verdicts touched the widespread rioting in Los Angeles. More than 40 people were killed in the riots, more than 2,000 were injured, and nearly $1 billion in the property was destroyed. Los Angeles Mayor Tom Bradley declared that there appears to be a dangerous trend of racially motivated incidents running through at least some segments of the police department, and President George H.W. Bush announced that in May the verdict had left him with a deep sense of personal frustration, anger, and that he was ordering the Justice Department to initiate a prosecution against the officers. On August 4th, 1992, a federal grand jury indicted 4 officers, charging them with violating King's constitutional rights under the law, color law, Powell Personal, and when were charged with willful use of unreasonable force against King. Kuhn was charged with willfully permitting the other officers to use unreasonable force during the arrest. After a trial, U.S. District Court, the Central District, California, the jury convicted Kuhn and Powell, but acquitted Wynn and Personal. Kuhn and Powell were sentenced to 30 months in prison. The jury was composed of 9 Caucasians, 2 African Americans, 1 Hispanic. King later won $3.8 million verdict from the city of Los Angeles. He used some of the money to establish rap records business. The issue to consider is whether officers King and Powell may be prosecuted and acquitted in California state court, then prosecuted in the federal court. This seems to violate the prohibition on double jeopardy in the Fifth Amendment U.S. Constitution, which the state's individual shall not be twice put in jeopardy of life or limb. Double jeopardy means that an individual should not be prosecuted more than once for the same offense without this protection. The government could subject people to a series of trials in effort to obtain conviction. It may surprise you learn that judges have held that the dual sovereignty doctrine permits the U.S. government to prosecute the individual under the federal law who has been acquitted on the state level. The theory is that the state and the federal governments are completely different entities, and that the state government is primarily concerned with punishing officers and with protecting residents against physical attack, while the federal government is concerned with safeguarding the civil liberties of all Americans. Each of the entities provides a check on the ensured fairness for citizens. The evidence introduced in the 2 prosecutions to establish the police officers' guilt in King was vertically identical, and the federal prosecution likely brought to a response of political pressure. On the other hand, the federal government historically has acted to prevent unfair verdicts, such as the acquittal of members of Ku Klux Klan charged with killing civil rights workers during the 1960s. Do you believe that this was fair, subject to Los Angeles police officers to expense the emotional stress of 2 trials, as the Attorney General United States would have advised President George H.W. Bush to bring federal charges against the officers following their acquittal by California jury? Chapter summary. Criminal law is the foundation of the criminal justice system. The law defines the acts that may lead to arrest, trial, and incarceration. We typically think about crime as involving violent conduct, but in fact, broad variety of acts are defined as crimes. Criminal law is best defined as a conduct that is shown to have taken place will result in the foremost solemn pronouncement of the moral condemnation of the community. Civil law is distinguished to criminal law by the fact that the primary protects the interests of the individual rather than interests of society. The purpose of the criminal law is prohibit conduct that causes harm, that threatens harm to individual and to the public interest, to warn people of the acts subject criminal punishment, to define criminal acts and intent, to distinguish between serious and minor offenses, to punish offenders, and to ensure that the interest of victims and the public represented at the trial and its punishment of offenders. In analyzing individual crimes, we will be concerned with several basic concerns that compose the general part of the criminal law. A crime is composed of concurrence between a criminal act, actus reus, and criminal intent, mens rea, and the causation of a social harm. Individual must provide with notice of acts that are criminally condemned in order to have opportunity to obey or violate the law. Individual must also be given opportunities at a trial present defenses, justifications, and excuse to criminal charge. The criminal law distinguishes between felonies and misdemeanors. A crime punishable by death or imprisonment for more than 1 year is a felony. Other offenses are misdemeanors. Offenses are further divided into capital and other grades, the felonies into gross and petty misdemeanors. A third level offenses, violations or infractions, acts of punishable by fines. Another approach is to classify crime in terms or moral turpitude. Mala and say crimes considered inherently evil. Mala prohibita crimes are inherently evil and are considered wrong because they are prohibited by statute. Our textbooks categorizes crimes in accordance with the subject, the matter, offense, the scheme that is followed in the most state criminal codes. This includes crimes against state and criminal against a person, crimes against habitation, crimes against property, crimes against public order, crimes against the state. There are a number of sources of American criminal law. This includes the common law and the state federal criminal codes, U.S. constitutions, international treaties, and judicial decisions. The English is common.